Okay, Chairman Lumsden, 410, I've got LC version 412899. Floor is yours.
That is correct. Mr. Chairman, members of the committee, I bring to you House Bill 410, the LC number just referenced. This is a bill that I presented last week in the subcommittee. It simply transfers the regulatory responsibility for bingo from the GBI to the Secretary of State's office. The holdup, as I recall, had to do with a physical note, which is in the process of, it has been requested, and it's my understanding that we only need the physical note before it goes to the floor. So that's the posture of the status of the bill, and be glad to answer any questions.
Any questions for the chair? Or, I'm sorry, for Chairman Lumsden. Does this bill authorize bingo to be played by electronic, non-verifiable means, or is this only paper copies?
This bill changes absolutely nothing about bingo. The only thing it changes is who regulates it.
Okay. Do you know, I know there was some discussion, I think there's, for those who might not have been here before, there was 119 bingo licenses in the state that were, I think the GBI testified to that last hearing. And wasn't sure if there's any other relevant facts, but I'll leave that to members of the committee to ask. Chair recognizes the chairman.
Thank you, Mr. Chairman. Chairman Lumsden, this bill, it doesn't change the necessity to get criminal background checks or anything like that. We're just essentially taking the regulation of those licenses from a investigative Georgia Bureau of Investigations to a regulatory agency such as the Secretary of State. Is that correct?
That is correct. That's the whole intent behind the bill. The GBI is an investigative body. I believe the role, the function of the GBI, I think they need their manpower to investigate criminal activity. Bingo needs regulated, but the Secretary of State's office is their role, their function is more regulatory. They regulate many, many things, so it would be more appropriate to be with them.
Thank you, Chairman Lumsden. Thank you, Mr. Chairman.
And two other questions for you, Chairman Lumsden. We did ask you the last subcommittee meeting. In fact, one of the reasons we held this over was just to make sure there was a chance for an inflection point for you and the Secretary of State's office to talk and give them a chance to be here. Perhaps they had missed it. It's my understanding are there any representatives of the Secretary of State's office here today that would like to speak to this? Seeing none, I think I know you've had a conversation with their external affairs representative, and they've chosen not to be here today to speak to this. With respect to a fiscal note, I understand the chair has requested one for you. Correct. Which is a requirement before its floor consideration, not specifically for committee.
Correct.
Although, because it's just a transfer of responsibilities as a net to the state, there doesn't seem to be any significant long-term impact fiscally, I would assume.
That would be my assumption.
Okay. Any questions from members of the subcommittee? Is there anyone else signed up to speak on this? Don't think there are. There's not. So with that, what's the pleasure of the subcommittee? Got to move due pass. Do I have a second? And a second. Any discussion on the motion? Hearing none, all those in favor of sending HB 410 LC version 412899 forward to full committee with the due pass recommendation signify by raising your right hand. All opposed? Passes.
Thank you.
Thank you. That's right. If it's the desire for anybody here to raise their left hand, that's something that they're used to raising more frequently. We can do that too. That might be maybe too much information for some. Chair recognizes Representative LaHood, House Bill 363.
Thank you, Mr. Chairman and committee. I'm here for the second time to present House Bill 363, which is designed to protect our elders. And it's necessary because our code needs more clarity on how to sentence for certain types of exploitation against elders, and abuse of access is the subject of this bill. And we're just clearing up and splitting the definitions to make sure that when someone is charged and convicted of abuse of access, that they can be sentenced appropriately, and so that the rule of lenity does not step in and cause the charged person to get the lesser sentence.
And to members, I think many of you were here when we heard this the first time. The goal is to make sure that there were code sections that are referenced by this that aren't inside the four corners of the bill as it's drafted. So we want to make sure members had a chance to get out and look at 16.5.100, 16.5.102. Appreciate the PAC representative who spoke articulately last time to this being here in case there were questions. So I just want to make sure members had a chance to do that, because it was a little less clear coming in exactly all that was happening. There were some moving parts and pieces that I think we've had a chance to delve into. Any questions from members of the subcommittee to the author or to the PAC representative that was kind of the technical advisor for the bill? Hearing none, is there anybody who signed up to speak for this wasn't heard before? Okay. I'd like to thank you, Representative Hood, for this. These are things that when statutes are enacted at different times and years, they work together in a way that sometimes they work at cross purposes to each other. So I think this kind of consolidation is important. I appreciate you bringing the bill. I have no questions from members of the subcommittee. And with that, what's the pleasure of the subcommittee? I've got a do pass motion on House Bill 363, and we're working off of LC version 338545. Do I have a second? And a second. Any discussion on the motion? Any discussion on the gentleman's motion? Hearing none, all those in favor of sending HB 363 LC 338545 forward to the full committee with a do pass recommendation signify by raising either hand. So ordered. Thank you.
Thank you.
Yes, sir.
Appreciate it.
Now that I'm 65 plus, I'll certainly make sure no one abuses me.
That's right. But by the way, because the lady identified herself as 65 plus, if you know the representative to my left, I would strongly suggest you not even attempt or think about abusing her, because you'll find yourself abused duly. And lady carries her years exceptionally well. With that, House Bill 258, Representative Saines. And again, Representative Saines brought his to our subcommittee. There's a lot of discussion about it. There were some substantive pros, cons. I think you're bringing a committee substitute, so Representative Saines, broadly, before you get into the details of the sub, I'm going to have you walk through the differences. Could you, for those that weren't in committee before, briefly kind of walk through, maybe not the detail you did before, but just kind of give us an overview of what you're doing with HB 258 substitute?
Sure. Trying to figure out how to put the laptop in this at the same time. So 258 minimum, let me re-pull it up. There was a defense attorneys wanted a copy, so this bill, and the LC number is 0372S, takes out aggravated sodomy and child molestation. All parties involved were in agreement that putting it in those acts would not change what that protection is already there. So it leaves only sexual battery and aggravated sexual battery. And in that, for the use of, to allow consent to be assumed, lack of consent to be assumed, we have raised the threshold, and it's evident in line 12, and then paralleled for aggravated sexual battery with the added language of for the purpose of sexual arousal on the party of the alleged offender. And I've talked to the committee chairman, and I'm in agreement to add or victim at the end of that, before the comma and after offender. Or I guess you'd add a comma too.
Sure. So broadly, again, we're dealing with this issue of clarifying in initially 4 code sections that below the age of 16, someone cannot consent to a sexual act. You've taken out 2 that you think exists. That's already clarified in law and is not needed specifically, although it was a clarifying measure. You've taken that out because there had been some debate about how those elements would play out in court. To simplify just around these, Section 1 and Section 2, which was the previous Section 3 and Section 4, if I'm not mistaken. Is that correct? Okay. So again, this arises out of State v. Williams case in particular and some other cases that feed to this. Are there any questions by members of the subcommittee to the substitute? Chair recognizes Representative Kendrick for a question.
So I have a crazy legal hypothetical. We have sex trafficking is really bad here in Atlanta, and a lot of these young girls are sex trafficked through strip clubs. So if for some reason a young girl is or victim is under the age of 16 and they are in these strip clubs and there is some type of they're being worked on the stage and there's some type of sexual arousal, but the person who is viewing this doesn't know that they're under the age of 16 and it's for the purpose of sexual arousal, are they going to be prosecuted then? Does anybody understand my question?
Well, to the lady's question, we are talking about we're talking about batteries here. So we're talking about touches, not looks.
Oh, gotcha. Thank you.
There is a difference in
Gotcha.
these.
Gotcha.
And I don't know who here has the most experience with that setting, but I am a believe there's no touching legal in that setting. That's my common understanding.
Okay. Gotcha.
Okay. Chair recognizes Representative McLaurin for a question.
Thanks, Mr. Chair. Could we potentially get PAC, Mr. Smith, to weigh in on how, in practice, this is going to work? Because my understanding is, last time we were making a distinction between affirmative defenses and negating elements. Mm-hmm. So this is the affirmative defense, and it now has this for the purpose of language. And one of the questions raised at the last sub was who makes the determination about whether it was for the purpose of. Well, certainly, I have a little bit of experience with this, but not a lot. So could you explain, is it like an emotions and limine posture? Is it upon a verdict? How would it work out in practice that the fact finder would say this was for the purpose of sexual arousal?
That's right. And Mr. Smith, let me just say for members who are viewing today, there's 2 groups that have special status here. The Prosecuting Attorney's Council and GACTL both can be called on when you walk through the door of that room, you're subject to be called on. So I appreciate your indulging the question, Mr. Smith.
Thank you for the opportunity, and as always, we stand here to assist and provide any information that may be helpful or confusing or whatever else we can do to assist in the legislative process. The question is that would this be a motion in limine? Affirmative action, affirmative defense, I guess.
The question I've got is, I'm glad that the committee narrowed this discussion for this purpose so that we can assess how this actually works. So if you're the prosecution and you want to bar the defendant from raising a consent defense in a certain type of case, how does that play out? Is that when in the process does that defense get barred, and does the prosecution have to move for it? And I guess my question is, ultimately there's going to have to be a factual determination about whether the conduct was for the purpose of sexual arousal, and I'm getting the sense that might not be the jury that decides that, because the whole purpose of putting this in is so that we don't introduce evidence of consent at the trial, was my understanding. So.
Well, first off, as an affirmative defense, the defense has to raise it.
Right.
So if the state, I would not expect the state would say, okay, you can't raise this defense. It has to be, the defense has to put forth an affirmative motion saying, we are raising the affirmative defense, or we're pleading as a matter of course that we're raising this defense. And then the state has to overcome that defense by presenting evidence beyond a reasonable doubt that it did not have, the affirmative defense is not made out.
So it would be a jury determination ultimately.
Yes.
And the jury determination would be as to the purpose of sexual arousal.
I think the answer is yes to both questions.
Okay.
That basically,
Okay.
this language, looking at the sub, the jury would have to make a finding beyond, or the fact finder, jury or judge, would have to make a finding beyond a reasonable doubt, the intent of the offender was for either their own sexual gratification, their own sexual arousal, or the sexual arousal of the victim. I want to make sure I understood the chairman's.
That amendment's being contemplated, but I think that is part of it. I was saying that's tending how we're doing it. We're tending to say either. Code used to have one sometime, but I think we're tending to have arousal of either is the standard.
I just want to make sure because I thought I wrote it down correct. I just want to make sure I did in fact write it down that you wanted that it would be an or the defendant or the victim, either one of their sexual for their sexual arousal. The conduct was done for that express purpose. That is an element of the crime now that would have to be proven beyond a reasonable doubt to the fact finder. And one other thing to also, and this is a point that I made last time, I want to make sure I express it to you. For something like the affirmative defense of justification, when someone uses force to repel what they think is an attack or for whatever reason, they can raise that as an affirmative defense. You have created a mechanism which there is, in fact, an immunity hearing. If the judge comes back and says, the judge makes the determination whether or not the defendant is entitled to immunity for the act. The judge can come back and say, no, you're not immune. That doesn't foreclose evidence still being presented at trial. So there is still, this doesn't foreclose the defense. The defense can raise, hey, and it's out there.
Okay, so ultimately, what I'm getting the sense is that what this bill actually does, and I think this is the point of the bill, so I think it's a good thing, is it reduces this question in these under 16 cases to, does the jury find beyond a reasonable doubt that there was an intent of sexual gratification?
Yes.
And I think that cleans up, I think, the issue.
Not gratification, arousal.
Excuse me, yes, arousal, right.
That's the word you chose.
To be specific, right.
Chosen.
Yeah,
Yes.
that's right. Okay, well then, and so if the judge found it as a matter of law, it would just be through the traditional channels in which judges can take questions from juries. It wouldn't be anything different.
Yes.
Okay. Sounds good. Thank you.
May I retreat?
Any further questions for Pat while they're here? You can stand by for us. Stay close. I appreciate the presentation and to the author of the bill. Any questions for the author? Who do we have signed up to speak on 258 substitute? Do we have a sign up list here? Let's suspend just for a second. We'll go get that list. Given our caseloads in Cobb County, this is the easiest work day you've had in a long time, isn't it? Okay. I've got no one signed up to speak on 258. Is there anybody here that'd like to speak to the 258 substitute? Okay. Seeing none, the chair recognizes Representative Kendrick for a question.
I just wanted to clarify in the top portion is to provide a response to a Georgia Supreme Court case. Is this to respond to it or to codify what the actual Supreme Court ended up holding?
It was created in, I don't know. What would the distinction of that be for?
Like I didn't know if in that holding they said something wrong and you're trying to correct it with this piece of legislation, or are you trying to codify what the
This
court
is-
said in that whole?
Yeah,
in that
this
holding?
is, the court detailed that because aggravated battery did not have the exception to not prove consent, that would be, it was inappropriate for the lower court to not have proven that element, even though they did uphold it because they have wonderful legal term, I'm sure, folks, that any reasonable court would have still upheld a conviction.
Okay. Any more questions for the author? Okay. With no speakers, what is the motion on the underlying substitute HB 258 480372S? Got a movement do pass? Second. Have a second? Chair recognizes Chairman Burchett for a question. Okay, he waves. So we have a motion on LC 480372S. Any discussions or amendments? If there's not, the chair wants to suggest at the consistent with the will of the author on line 13. It would read, it would be inserted on line 13, this language, as well as on line 19, after alleged offender. It would read, when the alleged victim is under the age of 16 and the conduct is for the purpose of sexual arousal on the part of the alleged offender or alleged victim. Let me ask a question to the ether out there. Would it be better to say sexual arousal on the part of either the alleged offender or alleged victim, or should it read on the part of the alleged offender or victim? Does the word either change that? Is there any thoughts? Doesn't change it? Okay. So we would add, I guess the contemplated amendment would be after the words alleged offender, add or alleged victim, comma, both on line 13 and again on line 19. That's what we had discussed. Is there a member who would move that as a formal amendment? I'll move it. Got to move. Is there a second? Second. And a second. To the author, any discussion on that? Highlight for us which you understand that to mean. I'm good with it. Okay. So in essence, one of the issues that came up was if the gratification wouldn't just be by the actor, it would be if the actor was able to demonstrate, well, it wasn't for my gratification. If they were speaking, it's for the gratification of the person that's the alleged victim. It would still fall in the boundaries of this crime. Chairman Burchett.
Thank you, Chairman. I think that in following what I have of State v. Williams, I think that accurately depicts what the court was trying to do, in that it's not only reaching the offender's actions, but also if it is for the arousal of the victim. I think that's a very good transition.
That does speak to the fact pattern of Williams. There was a young child that the perpetrator claimed that the child like this was aroused by it, and that was all part of why they were making this claim of consent. Representative Kendrick.
I have a question about what would happen if we change that to or victim if both, if there were two parties under the age that were 16 and under. I know we have Romeo and Juliet type laws, but does that make a difference if both of them are under the age of 15?
Well, there's a circumstance where if both were under the age, then it'd be a delinquent act under our juvenile code, but it still tracks against that. We do have what's called a Romeo and Juliet provision, and I need to go back and see if they both apply to these code sections. The felony codes, I'm going on memory, which is dangerous. If these acts that pop to a felony, if it's 18 years of age and the person's within, I think, 48 months of age, but still older than 14, I think it becomes a misdemeanor. I don't know if it's 22.1 or 22.2 that applies to.
I don't believe these offenses have a Romeo and Juliet in general, and but when we did have the added offenses, that was a question from one of the sponsors, and legislative counsel did indicate that it wouldn't affect the Romeo and Juliet provision. So if I'm incorrect that there is a provision here, we didn't change the bill to where that opinion would have been modified, that this would not affect the Romeo and Juliet provision.
Yeah, this is, there's not one 22.1, and I'm looking at 22.2 right now. So, gentleman's correct. There's not a Romeo and Juliet in this one. Questions? Representative Smith, question.
Mr. Chairman, I think procedurally I need to withdraw my motion from earlier because I had moved that we do pass without the chair's amendment to that.
No, that's okay. We actually have to be in a posture to receive amendments. We have to have a do pass motion on the table, and then we get in that posture. So I appreciate you doing that. Yeah, it's a little awkward. When I first got down here, that seemed. I was trying to race to my amendment before people were racing to a do pass motion, and we do have to get that posture. So I appreciate the clarification. Chair recognizes Chairman Burchett for a question.
I don't.
Okay. Any further discussion? We've got the motion and a second on the amendment to add or alleged victim after alleged offender on lines 13 and 19. Is there objection to the adoption of the amendment? Is there any objection? Hearing none, the amendment's adopted. Okay. So we have the underlying motion of due pass for HB 258 LC 480372S. Any further discussion? Hearing none, all those in favor of sending the committee substitute forward to full committee with a due pass recommendation signify by raising either hand. Thank you. Thank you.
Always a pleasure.
You bet. Okay, Representative Gunter, HB 371. And I've got to needle the gentleman just incessantly. This is not Representative Gunter's first time before this committee, but he was playing a different role in his visits before. I hope it's just as entertaining for you now as it was then. Welcome back.
Actually, it is, I think. The version I think you have is the original at LC 280112. Is that right? And I have a committee substitute that I would like to pass out if I may.
Okay, please.
The substitute was what I intended in the first place, but what I actually did was Senate Bill 344, I think was the number from last year, was the version that I took to Legislative Council and had them draft it up. But in discussion with several of the parties that are involved in this, we knew it needed to condense the wording and hopefully make it a better bill. This is the video conferencing bill. This has been going on in Georgia for a long time. When I was district attorney back in the early 2000s, I remember my magistrate judge in Lumpkin County was one of the first judges in our area to start doing first appearance hearings by video conference. And mainly what was holding everything back in those days was that you had to have the equipment and the cost of that. It's been around long enough. Department of Corrections has actually invested in some of that equipment, and the courts across the state have appearances by prisoners, video conference-wise. And basically what this bill does is it codifies the rules of the court, mainly the Superior Court Rule 9.2. And I just want to hit a few highlights of that rule so that you kind of understand what the courts are doing with this. Video conferencing has been a vital to the court's ability to conduct business. 9.2 has been modified slightly during the pandemic, but the changes only applied to the duration of the judicial emergency. The 9.2 is the rule that allows for video conferencing under limited circumstances and only in limited types of cases. The rule does not allow for video conferencing in any jury trial or bench trial. It does not allow for video conferencing if a probation violation, in a probation violation hearing, unless the probationer admits. And those are, if you've ever attended any of those, very short 5-10 minute meetings. You go over their rights, make sure they understand what they're doing, and then you administer whatever punishment there is from that. The rule allows for video conferencing in most of the preliminary matters that come before a court: bond hearings, initial appearance, preliminary hearings, arraignments, those kind of meetings like that. These are hearings where there's no guilt or innocence determinations being made. That's basically what we're doing with them. The rule allows for video conferencing in guilty plea hearings. It allows for video conferencing in post-judgment cases. So after you have someone that's pled guilty or had a jury trial and they were found guilty, motions for new trial, things like that can be heard by video conference. And this, especially at that stage, is where this rule protects everyone involved. It protects the inmate, protects the, and what I mean by that is it's a safety provision for the inmate, for the officers that have to transport that inmate if it were to be an in-person hearing. If there's interpreters involved, they can do their work by video conference. The trial judge under Rule .9 always controls whether it'll be an in-person or a video conference. The rule specifically protects attorney-client communications and requires that the attorneys and clients be afforded the means of a private communication. Typically, the trial court arranges for non-recorded telephone access between the attorney and client during any video hearing. It allows for both parties to call witnesses and have them testify via video. However, there must be pretrial notice of the intent to do so, and if the other parties object, video testimony cannot be had in a criminal hearing. However, the judge retains discretion in a civil hearing. All video hearings must be recorded and transcribed. If there's a search warrant application and it's done by video, that's allowed under this rule. And under this rule, all participants must be able to see and hear simultaneously as the evidence or hearing is conducted. All participants must be able to see and hear all physical evidence, and the video quality must allow all participants to observe any nonverbal communication or demeanor of the witnesses. The trial judge conducting a video hearing must be located in a public courtroom. And I wanted to tell you that this rule has been around since 2004, not in the form that it is today, but over the years, they've taken the best practices that have been going on around the state and compiled this rule to what we have today, and much of what I went over is what that's about. Let's see. LC 280230. Basically, if you want me to, I'll go through each line of the bill so that you understand what that is. This is adding a new code section, 2413.8. Judge of any class of court of this state may conduct hearings by telephone or video conference. And it's usually by the uniform rules of that particular court. And if there isn't any in place, then it would be under Rule 9.2 of the Uniform Superior Court Rules. This would also include Office of State Administrative Hearings and their judges and what they conduct. Also, the Georgia Tax Tribunal can conduct hearings per this rule. Judges of all classes of court are authorized or required to administer oaths, and they can do that by video. This allows them to do that. Now, in C, video conferencing shall not be authorized for use in any criminal trial where the accused's guilt or innocence is to be determined unless otherwise authorized by law. So if the defendant requests a bench trial, the court can do it that way. If the court determines that it should be done that way, it's in the court's discretion at that point.
And Representative Gunter, could you explain that a little bit more? So if a bench trial is requested, what's the circumstance that happens?
Well, it's the last phrase there where it says otherwise authorized by law, and the circumstance that I can think of is this: if the defendant requests a bench trial and there's no objection under current law, no objection by the prosecutor, then it could be conducted by a video conference if those parties want it done that way.
But both parties have to consent to that?
Currently, yes.
But, and your policy objective is to change that or leave that alone?
I'm leaving it to what they have in 9.2. That's what's in 9.2. That's basically what we're doing is we're codifying the rule here.
Mm-hmm. So if the defendant is comfortable with a bench trial, criminal bench trial being done remotely by VTC,
Mm-hmm.
this allows that to happen, but they could object and insist on doing it in person, is what you're saying?
Right. I believe under the rule that they would be allowed to object and move that into the trial court for in-person.
And I'm sensitive, both the
I have a backup here that
he's a pretty able backup.
that may be able to help me out here. So,
and I say this just because there's two things. Thing one is clarity. Let's get clarity on this, and then and I would say too. We think about this issue of delegation. If the rules were to change, and by operation of the statute we're passing, what is enacted changes. If a rule change happened, we can't. Some would debate that we could, but I think we do well to say in statute what's allowable, what's not allowable. That's just a clarity issue.
right.
Writing these things out clearly so someone can read this and understand what's possible, what's not possible. And then there's the policy question. Do we like the policy? Do we not like the policy? But I do. It does make me a little concerned when we start codifying or even referencing things outside of the statute. What effect that has? Because we can't have we can't delegate to something, as it were, and then it can shift and move on us. So that's we just need to structurally make sure we're understanding the way
Sure.
that works. So I'm sorry, keep going.
Okay. Let's see. All right. Basically, in D, it's the code section won't be limited or by any. In other words, Rule 9.2 is the rule that it can be amended or modified by the Superior Court rules, by how the judges do that process that they have in place. Let's see, in E, where they're conducted remotely, okay, if the judge, let's just say it's a matter that doesn't require a jury, and the judge is actually sitting in his office and not necessarily in the courtroom, this doesn't invalidate that hearing or whatever it was they did. In F, proceedings shall be deemed to have been conducted in open court, provided the judge, clerk of court, the public are capable of nearly simultaneously observing the proceedings. And if you're sitting in room 341, you'll understand what that means, because the video is always behind the voice that we hear. And then in G, basically, it's toward the end of that where it says it's merely intended to codify existing practices. That's what this bill is about, is for the legislature to make this the policy of the state. And from my experience, I believe this is the future of our court system. We're headed this way. And it saves lives. There was an incident not long ago, if I understand the situation right, something didn't get completed in the original hearing, so they had to bring the inmate or inmates back to the court for a brief hearing. And on the way there was an attempt to escape, and officers lost their lives. So this is a safety measure. It's a cost saver. for the state and for local government. I know the prosecutors are in favor of this bill. The Public Defender's Office is in favor of this bill. I have not talked to Gactel specifically about this substitute, and I don't know that they probably have taken a position against the original 371, but I'm not sure about this version of it. So.
Okay.
And I'll take any questions.
Chair recognizes Representative McLaurin for a question.
Thanks, Mr. Chair. Thanks, Representative, for a sub that, on its face, I know I like a lot better than the original 371 that was filed. We're talking about codifying, and the word codify exists or is printed at line 39. In some ways, and I don't know if you'd agree with me, this is different, it seems to me, from a codification that is to take the current text of the rule and just drop it in the code. It seems like what we're really doing here is saying whatever Rule 9.2 might be as determined by the courts, there's certain state law obstacles to that we're going to make sure out of the way. Like, for example, we're not going to flip any result of a proceeding because the judge wasn't there. It's going to be deemed to be an open court, that sort of thing. So in a way, it seems to me we're still deferring to the courts on what 9.2 is, but we're just making sure that state law doesn't interfere with the operation of the rule. Is that basically right?
That's correct, yes.
Okay. That to me seems a lot safer than the normal case of just we're going to take whatever the current, cross-section of a rule is and put it in a statute.
That was the problem with the original filing that I did, was because it detailed out and you don't catch everything, you don't word it right. 9.2 has been built by the practical application over the years. So
right.
We're taking that wisdom and putting it here.
And again, because of the nature of the courts and their sort of self-direction in so many ways, it is a different issue delegating certain things to court rules than it would be in other parts of the code. I recognize that. I just drawing that balance and making sure we're very careful about how we draw it. That was the question. That was the reason.
And it is when you change this, it's the Judicial Council and it's made up of all the courts, right?
Right, with the Supreme Court Act.
Come on up.
If I may, Mr. Chairman, thank you so much. Judge Tane Kell from Cobb County Superior Court.
Welcome.
So the reason for incorporating Rule 9.2 into this statute in particular is 9.2 only addresses itself to video hearings and criminal proceedings. Criminal proceedings, already by law, by United States Supreme Court law, there are certain what they call critical phases of a criminal proceeding that must be held in person, that we would not under the current law from the United States Supreme Court ever be able to hold by video, and we understand what those are. However, as that case law continues to evolve, it changes. And if we tried to enumerate every one of those critical phases of the criminal proceedings that we cannot hear via video conference, we would constantly be attempting to amend the law. And as you know, it's easier for us to amend the rule to include those things. Because if you look at Rule 9.2, which applies to criminal proceedings, as opposed to 9.1, which applies to civil, 9.1 that civil says you can do essentially anything except the following things. 9.2 says you can only do the following types of hearings via video. And there's a reason for that. That's because we want to enumerate the only times that video hearings can be used. And then again, as that case law evolves with the U.S. Supreme Court, we want to be able to incorporate that in. And the other thing I was going to say to what Representative Gunner was about to say is, the Georgia Supreme Court has to actually approve uniform superior court rules before they can become uniform superior court rules. And so the backstop for us whenever we have a bright idea as superior court judges is we have to run it up to the 9 justices of the Georgia Supreme Court and make sure that they believe that it passes Georgia and United States constitutional muster before that gets passed. So hopefully that answers the question, but that's really the reason for incorporating 9.2 in here. 9.1 is not incorporated because 9.1 is kind of an open-ended non-criminal statute.
Well, and Judge Kellum,
yes,
when you take the stand, you're subject to cross-examination, right?
And I freely do, because as you mentioned earlier, even just being down here today is a wonderful break from what we've been doing for 10 months, 11 months now. Thank you.
No, but I do think, just to put a fine point on it, though, while it is true that as case law emerges, this could follow it, that would sort of set a minimum bar. I mean, if you see the U.S. Supreme Court is establishing sort of minimum standards, the states would, and in some cases it doesn't work that way, but they'd say at a minimum, these are the circumstances that you have to have in-person hearings.
Yes,
if that changed, if there were 4 circumstances and they reduced it to 3, I mean, it is the prerogative of this legislature to say we want to keep the 4 in place. Maybe the minimum standards, what SCOTUS says, but that's why I wrestle with what's the appropriate reliance on rules in our courts, and what's appropriate for us as a legislature to say these are the circumstances that thou shalt not do a video hearing. And that's what we're wrestling with.
And I totally understand that. And one of the reasons that, quite frankly, we want, and I say we, Department of Corrections, and we have Mr. Cooper back there from Department of Corrections who drove up to talk about this too. But one of the reasons that we wanted to bring this before the legislature is we've been operating under these rules for, as Representative Gunter said, for years. And Rule 9.2 with respect to, let me back up. At first, it was telephone conferencing. It wasn't even video conferencing. The Rule 9.1 and 9.2 allowed certain things to be done by telephone conference. It was then modified so that we could do video conferencing, which is infinitely better. And so the rules, we wanted to bring it before the legislature to make certain that the legislature put their imprimatur on what we were already doing, not to change anything that we're doing, but certainly to give the legislature the opportunity to say, yes, this is something that in the state of Georgia comports with the policies of what we want to do as a public body and continue to do. And so but we believed we still had to build in some flexibility to allow the rules to continue to evolve as the law changes. And I did want to say, with respect to the things the Supreme Court normally comes down and tells us, and I'm talking about the U.S. Supreme Court more than the state Supreme Court, what we generally get from them are prohibitive things. This was in a gray area before, but we're now saying this is prohibited going forward. And obviously, those are things we would have to follow no matter what. I mean, even if there was a statute that ran contrary to that, if the U.S. Supreme Court said we can't do something, then we can't continue to do it unless there's an amendment that says that we can to the U.S. Constitution. So hopefully that answers your question as well.
Question, and this is something I may pose this to others as well, but I do view a video conference as being, although it's remote, I do view it as being superior to a phone encounter. I've had some phone calls that have gone sideways on me just because you don't have even the ability to read facial, expressions and things just to help communicate and make points. Do we really need to codify phone conference moving forward? Is that something is that antiquated to the extent we can say we're not going to do the phone thing, but we're going to consider the video thing?
I would say that we do still need to do that, and I'll tell you why. It is much easier, even in this day and time, for me to get 3 or 4 or 5 attorneys on the telephone in short, on very short notice than it is for us to set up a Zoom call, have everybody join in, make sure everybody's off mute, make sure everybody's Wi-Fi connections are adequate to do a video conference for something that may take 5 minutes. So for example, in a civil case for a pretrial conference, I just get on the phone with the parties, we put them on speakerphone, it doesn't have to be reported by a court reporter. We may have a 15-minute telephone conference and be finished. Nobody ever has to leave their office, nobody has to jump on Wi-Fi, nobody has to do those sorts of things. So from my perspective, it still has a value for some of the things I do on a day-to-day basis.
Yeah. And I just asked the question because as we have, newly minted Superior Court judges that are coming into the system, they're going to tend to be products of the system they came up in. They may be less grounded to sort of the inherent value of face-to-face encounter. So I just say that parenthetically for the committee. I think there's real value in face-to-face, and I think as we move forward, we can say times have changed, but that may be more a matter of opinions have changed, not the nature of the way court proceedings play out. So it's it's something we're balancing. Representative Kendrick, do you have a question for Judge Kell or for the author?
For anybody who can answer it. So,
Well,
from,
then stand.
for line 13 through 15, this does include the Georgia Supreme Court. Is that what I heard you say? I'm not familiar with. I'm just a transactional lawyer. I do not go to court at all.
Yes, ma'am.
I think it reads that way.
Yes, ma'am.
Any class of court.
Yes, ma'am.
Okay, and then
And the Georgia Supreme Court, just for your information, has been conducting their hearings in the Supreme Court via video for the last 11 months.
Yeah.
They've done all of since March.
But to be fair, that's pursuant to a judicial emergency. That's not.
That is correct, but I would guess that many of their proceedings may continue to be conducted by video afterward as well. I've spoken to some of the justices about that, and because understand the nature of their hearings in the Supreme Court is it's 99.99% of the time lawyers just arguing points of law. It's not presentation of evidence or any of those sorts of things, of course. So that's the reason that a lot of their proceedings can be conducted a lot more easily than what we do in the trial court via video.
And I got a secondary follow-up question. So if that's the case, is there a statutory difference between the use of the word judge and justices?
Yes, ma'am. Supreme Court justices are the only justices in the judicial system. Everybody else is a judge.
So I guess, so line 13, I guess my question is, are we taking them out of the running by only using the word judge?
Perhaps we should look at putting that back in there. They helped us draft this language, so I don't know if they were satisfied with that or not, but I think that's a great catch, and we can certainly include them in that as well.
Every lawyer has their skill set, right?
Yeah, that's awesome.
That's why I never looked.
Thank you.
So appreciate your presentation, gentlemen. I've got, does anyone else want to speak to 371 substitute? Chair recognizes Ms. Travis with the Georgia Association of Criminal Defense Lawyers. Ms. Travis, welcome.
Thank you. I apologize for my appearance. I was literally moving boxes in my office when we got notice of this hearing today.
And
donated furniture.
And to that point, broadly, we had to, I'll take that on me. There were some communications breakdowns that fall on the chair, so you have my apologies.
Thanks for hearing from me. I just wanted to express, we had substantial concerns about the original House Bill 371 and are satisfied with the substitute as in its current form. We appreciate the author working so diligently to make changes that are helpful to all of the parties and raised and answered some of the concerns that we expressed with Senate Bill 344 last year. So we are satisfied in its current form, judge or justice notwithstanding.
So questions for Ms. Travis? I do. I'm not, I don't have the 9.2 in front of me. I just, so understanding what it is we're doing, there's the clarity and then there's the policy. This is a clarity question. What civil proceedings are prohibited from being done outside of a judicial emergency? What civil proceedings in Georgia are prohibited from being done via conference, or is every civil proceeding eligible to be done by conference?
Civil proceeding or criminal? Civil.
On the civil side.
So one of the things that we'll tell you that's been very helpful to us during this judicial emergency order is the ability to do habeas, which is civil, and to have our lawyers not have to travel the distances to the prisons in the remote locations that they are located. One of the benefits, I believe, about the civil process is most of the time, if the parties consent, the proceeding can be conducted in a remote manner. That's an aim that GACTL has for 9.2. That's not currently one of the rubrics in terms of the listed items, but the Supreme Court is actually looking at revising 9.2 right now, and we always feel like whenever we can agree, we can say that can be done. I'm not an expert on civil practice, so I cannot answer your question more specifically with what can't be done or what can be done in the civil context.
Well, and I understand GACTL is certainly pleased with the movement on this versus the underlying, or the original bill. Having said that, do you have any questions? I'm just trying to unpack some of the language here with respect to, I won't call it unconstitutional delegation issues, but delegation issues, not enumerating which certain kinds of proceedings can happen remotely and which can't. I mean, I recognize it's the Supreme Court's, U.S. Supreme Court's designated those. Do we do well to enumerate those? I mean, my instinct is we need to enumerate and be clear on what we're doing and put it in statute. Do you all, as an association, do you have any opinion on that?
I think if you try to do that, you're going to run into another constitutional problem called separation of powers.
Understand? We balance that all the time. Appreciate it. Representative McLaurin, question.
Thanks, Mr. Chair. Again, just to be clear, I think, and I could be wrong in my grand constitutional theory of what's happening here, but I don't think that this is saying that Rule 9.2 now has the force of statute. I think what it's saying is that any state law obstacle that might exist to Rule 9.2 applying is basically removed. So, you know, you can't object on the basis that the judge is not sitting physically in the court, et cetera, et cetera. And what that does is almost like it's path clearing. It moves any sort of state law obstacle out of the way so that 9.2 can take effect. I think that's what's happening. Would you agree, Ms. Travis?
I would.
Okay. Thank you.
Okay, thanks, Ms. Travis. No further questions. Any further questions from members of the committee? Chair recognizes Representative Smith for a question.
Thank you, Mr. Chairman. Judge Gunner, I know we had spoken a little bit about this, and just to be clear, this would seem to me that it's going to radically change how we practice law in the state of Georgia.
I would disagree with that.
Okay. All right. I just wanted to make sure.
I would tell you that this is the way we've been practicing in court for the last 15 years.
Right. And I know I had shared with you some of the concerns I had with, you know, the interaction in person versus video conference and things that you can pick up on within the courtroom setting that you might not be able to via video conference.
Yeah, keep in mind that this rule's been around long enough that a body of case law is now around it.
Okay.
And when I served as a judge, I was very particular about these kind of hearings, and I wanted to make sure that, you know, I gave the defendant every right I could, because I didn't want to have to bring it back and try it again.
Right.
Okay? And it works the same way in the civil cases. I want to make sure that, well, and I believe that the way this is set up is that the judge retains discretion in civil cases, because we're not talking about life or death in those cases, mainly money. But there are serious cases for people, and if they want to conduct them by video conference, we should allow that to happen and leave it in the judge's discretion. But like I said, there's a body of case law out there that would guide the judge as to when he really should have an in-person hearing. And again, I wouldn't want to mess with somebody's life in a civil proceeding. I would give them the benefit of the doubt and have an in-person hearing if they strongly objected to it.
Okay. Thank you, Judge.
Yes, sir.
Chair recognizes Representative Kendrick for a question.
So on line 35, would you object to a grammatical correction that is driving me nuts? That says, and the public are, if we changed it to, and the public is capable of nearly simultaneously observation of the proceedings. Is that going to change it in any way? That would not drive me crazy.
I'm good with that change.
I recall the lady is an English literature major from an elite liberal arts college. I appreciate the contribution.
And I was a chemistry major, so I'm not real good at this anyway.
Point of order. Is friendly fire allowed? Because I'm going to object to that change. It's plural. It's a series of three. It's judge, clerk, court, and the public are together. All three of those are the subject.
Oh, okay, all right, but how about the, okay, well, I'm not an English major, so I'm not gonna object to that, but how about the part nearly simultaneously observing the proceeding?
Well, I think the reason it says nearly is because there's technically...
No, I'm not objecting to that part.
What's that?
I'm not objecting to the nearly part, I'm objecting to the observing, changing it to observation of the proceeding.
Well, it's capable of observing would be so nearly simultaneously there's adverbs to modify observing. So it would otherwise read the public are capable of observing. So I mean, it technically is correct, I think.
I'm gonna have to trust you, because it just sounds weird to me, but I'll leave it alone.
Chair recognizes Representative Byrd for a question.
Thank you, Mr. Chairman, and thank you, Representative Gunter. I happen not to be an attorney here, but so I want to be sure that I am one not to change seriously on most issues. But is it my understanding that when you have your video conferencing from this day forward, even though you have been doing it for the last 15 years, you have to be in either court or in your office at the courthouse or wherever your office may be?
And if there's any requirement that the public attend wherever the judge is sitting, the public has to be able to see what's going on.
And so as a judge that happens to be on camera, you definitely have to be in your robe and all the other things that are actually the real things of a court proceeding.
The robe is not required, but yes, you would want to abide by any of the procedures that you would have in a normal court.
Because we are becoming so lax about these video conferences. I mean, when even a state representative is presenting a bill kind of laying back in his chair in a car is very disturbing to me. So
I can't imagine a judge being in his car and conducting a hearing as he's traveling down the road.
Thank you.
You're welcome.
Any other questions?
To me, that's just inviting another case to define the law even further.
Representative Gunter, I've got a question. I don't see any questions from members of the committee just this minute. Lines 36 through 39 of the bill. I mean, although it's often the case, a new sub is held per se just for another hearing. I'll probably entertain a motion here at some point today. I'm trying to understand what 36 through 39. I don't know that I've ever voted on a proposition that says the proceedings set forth in this code section are authorized under existing rule and laws, and the inclusion of the procedures set forth in this code section is merely intended to codify existing practices. My instincts just tell me that doesn't sit right with me. This code section merely intended to codify existing practices. To me, that seems like legislative findings. I'm trying to understand what that clause does. What are we saying? And I'm wrestling with that.
Okay, I think it's saying what the purpose of this bill is to put into law the ability of the courts to conduct video conferencing hearings, and generally sets out the parameters that they can do that in, which is further defined by Rule 9.2. I think that's all that's saying, is we're making this the policy of the state.
But is subsection G necessary in the bill, and if so, why? What does it do?
I mean,
and particularly the second sentence of subsection G. It seems to me if we're going to codify, if we're going to give power to the Uniform Court, Superior Court Rules 9.2, that can stand on its own. There may be some things we would say where it shall not be construed to do A, B, C, and D. I don't understand what G's doing.
I would say that G is a feel-good provision, so if you want to take it out, that's fine.
My druthers are to do that. I just want to make sure we're crisp in what we're doing, that every line has a specific meaning and it's discernible and understandable.
Sure.
I'm personally not comfortable with unless otherwise authorized by law. I'm not going to lean in on that one, but G is a concern. So
Judge Kell, I think.
Judge Kell, thank you.
Mr. Chairman, the reason that provision was added, quite frankly, was in a discussion with with one of the Supreme Court justices who was assisting in some language on this bill. He expressed a concern that by codifying something, incorporating the rule, that somehow we might be left with the impression that we were also somehow saying that the way that things were already being done was inappropriate or something along those lines. And the whole reason for that provision is simply to say, hey, look, in this statute, we are acknowledging that we are codifying existing rules to continue to do something that is already being done. And that was the whole reason for that provision, sir.
I mean, and I understand that. I guess in my mind, you know, a section 1 or section 0.1 legislative findings that can elucidate that's still part of the legislative record.
Yes, sir.
But it's not written into OCGA, this new code section 2413-8 subsection G. That just doesn't sit right.
And we actually, it's funny you say that, because we actually originally drafted some language that was a preamble to this section that did exactly what you're talking about, and then changed it to make it section G. That's how it ended up at the end, quite frankly. But we did that, and certainly could do it in that fashion as well.
Okay.
Thank you.
Okay. Chair recognizes Chairman Burchett for a question.
I was just going to reiterate what you were saying, Mr. Chairman. Thank you. It kind of speaks to the intent versus there's no real practical effect of it. So I would, if you were at some point wanting an amendment, that might be one amendment that I'd be friendly to.
Mr. Chair, if I were to offer that amendment, I'd probably create a new section 1 and have it be legislative findings. In essence, it's not adding something to OCGA and then renumber the section. So that is still part of the bill that we're voting on. There's still legislative history to it, but I don't know how that operates once we put it into code. So, Chair recognizes Representative Smith for a question.
Judge Gunner, I just had one question. In interpreting this code section, would it be wrong to think that subsection G there would kind of provide a court examining this with a little bit of direction as to why this was done, and kind of confine them to which practices are included in this?
Yeah, I would think that, yes.
And so this would kind of be a safeguard if someone, tried to interpret this outside of the text itself. I guess I'm kind of getting into a little textualist bent here and making sure that this kind of goes to the intent of what the legislation is doing, and so could very well operate in statutory interpretation from allowing the justices to go outside of those bounds.
Right. I think I understand what you're saying, and I think this would help all levels of court actually to have this intent stated in there.
And I would
prefer to see it stay, but is it going to kill the bill if you take it out? No.
Yeah. And I would say parenthetically, when we think about legislative findings, there are a number of bills where a trail of breadcrumbs with legislative findings is the author's intent, and it is put in there, but it's not something that's necessary, needs to be written into code as such. It's intended for that purpose. So again, it'll be up to every member of the committee to decide that, but I think it doesn't fail to do its job in terms of expressing legislative intent to put it in legislative findings, because that's really the purpose of those. Any more questions?
And I agree with the chair. I just, tightening this up, I appreciate the work you did on it, Judge, notwithstanding some of the concerns I had earlier, and I thank you for addressing those. But I think leaving this in, that, from my standpoint, I think it would be better to guide the court in what they're doing. I mean, I would hope that everyone would be able to read this and statutorily interpret it the way that it's intended to be, but as we've seen American law go forward, it doesn't always stick to what the author may have intended. So as much as I hate that we have to even put a section in like this, I would still think that keeping this section would be good, because even though it might not be an issue 5 years down the road, I mean, we get 15 years down the road, and we've left the gate wide open for the whole herd to go out to pasture.
And to the point, though, if this were put in place, someone reading it in 2031 are they to read it to say intended to codify existing practices of 2031, 2026, 2015? I mean, we could say codify existing practices as they existed on the 23rd of February 2021. I mean, again, I just for purpose of discussion, I appreciate the interest.
Probably would help if we had some wording.
If that was going to happen, I think. But again, we'll appreciate the gentleman's answer. Chair recognizes Representative McLaurin.
Thanks, Mr. Chair. At the risk of piling on the discussion a little bit, I could see, and I'm asking the author if maybe you would agree with anything I'm saying. Would it be possible, in your view, to keep the first sentence and maybe tweak the first sentence to say, construed to modify to the extent that the practices are consistent with this code section, something like that, but then take out the entirety of the last sentence so that we don't create the ambiguity about codification? Because I'm seeing both sides of this. I'm seeing that we want to make sure that this isn't read in a way that goes out of control, but at the same time, we don't want to introduce ambiguity about what rules in particular we are or are not codifying.
I get that.
That seem amenable to you? Or?
Yeah, I think that's a good suggestion.
Okay, thank you. I'm not sure if
you agree.
Chair recognizes Representative Smith.
Judge Gunner, let me ask this. You're referring to Uniform Superior Court Rule 9.2, and that's subsection G, correct?
Well, I think it includes the case law as well.
Including the case law? Okay.
You agree? Okay.
Any further questions from members of the committee? Anybody else want to speak? Right now, I've got no one else signed up to speak. Does anybody that's here want to be heard? This would be your chance. I was in a committee once that Chairman Wendell Willard was chairing, and everything had gone great. And he asked, anyone else want to be heard? And someone who'd not planned to speak came up and spoke, and the whole thing came unraveled. Not trying to do that to you, Representative, but it was a thing to behold. Appreciate your time. What is the pleasure of the committee? Move to pass in a second. Can I move to pass in a second on the underlying HB 371, the substitute LC 280230S? Is there any discussion or amendments? Chair recognizes Representative Kendrick.
I only have one, since apparently I did not do well in English. For line 13, my suggestion is to add behind judge or justice to include the title for the Georgia Supreme Court.
May I make a suggestion on that?
Yes.
You might want to move that to have it read, a judge of any class of court or justice of this state may conduct, and go from there.
Okay.
So how does the lady want to state the amendment?
Like the representative said. Okay, so I move that we change line 13, starting at A, to be a judge of any class of court or
justice
of this state.
Okay.
And continuing on.
So, or justice between court and of on line 13. Okay. Is there a second on the lady's motion? Have a motion and a second. Any discussion on the lady's amendment? Hearing none, is there any objection to the adopting the first Kendrick amendment? Hearing none, it's adopted. Okay. Chairman Burchett.
Just a quick question. Means we made that change with the justices. Do we need to go through this line 21, line 15, and 16, or do you think that that is going to be satisfactory to include the justices all the way throughout the provisions of this piece of legislation?
Good question.
Okay. Yeah, sure. Judge or justice.
We can take a second, just an inflection point. We're not rushing here. The Setzler Subcommittee's never been known to rush, to the chagrin of us all. I do think that the question would address itself to when the clause, all classes of court. That's right. I would assume that they take oaths, but for when they swear in new justices or new attorneys to be able to practice before the court, they take oaths.
Yeah.
There are certain very limited trial proceedings that the Supreme Court can conduct as a trial court. I don't know of any we've had in the last 100 years, but yes, they do have original authority to conduct trials in a very limited set of circumstances.
Okay.
That is true.
Is there any other place in the bill other than lines 13 and 21, as the chair raised, that could be an issue?
Mr. Chairman, I might just say, following the modifications that's been made in line 15, it may need to say judges, comma, justices, or hearing officers acting under.
Thank you.
Thank you.
Okay.
And also on line 30, shall not be invalidated merely because the judge or justice was not physically present in the courtroom. I'm assuming that could happen.
Okay. Judge, justice, clerk of court, yep. What we will call this is, since the Kendrick Amendment was adopted, we would be adding these additional ones to this. We'll make this the second Kendrick Amendment, Chance? Okay, so as we've rolled up our sleeves, we've got line 13, or justice has been added. We're going to add on, I think what I'm hearing is this, what's being contemplated is justice being added after judges on line 15. Justice is comma.
Mr. Chairman, I would never add justices after judges. I would always put them ahead. That was my mistake, sir. Justices, comma, judges.
On the 23rd of February, Judge Tane Kell, Latane D. Kell. I mean, is it what's the pleasure committee? Is it? I mean, from a hierarchy perspective, it's obvious. Is it better to be drawn as judge first, since that's going to be the prevailing circumstance in which that's considered, or it's pleasure committee? Representative Kendrick, you still have the floor.
So I think, as was suggested before, if we leave it at judges, since that's probably going to be the one that most people are going to. Why are you looking at me like that, Representative McClure?
Wave.
Okay.
Representative McLaurin is deemed the chief of protocol for our subcommittee.
Right. So just judges, comma, justices, and then whoever falls after that. I mean, I really don't know what the protocol is for that. I don't have a preference.
Weighing in as chief of protocol, I will, to the judge's point, is so rare that a Supreme Court justice sit as a trial judge that maybe it's enough of a humbling experience that they wouldn't mind being listed second in that incident.
That's right. Okay. So what I've got after judges on line 15. By the way, they've already been inserted against their will on line 13 after judge. So we're talking about moving forward, right? Anything else would be out of order. After judges on line 15, or justices would come after classes of court on line 21. By the way, the most important person to capture this is to my immediate right, so as long as she's got it, we'll be fine. On line 30, judge or justice, and then on line 34, judge, comma, justice, comma, clerk of court, and so forth. Anywhere else that's relevant? Hearing none, does the lady state that in form of a motion?
Yes, do I need to repeat the whole motion?
I think we got it.
Okay.
I think we're good. So moved by the lady. Do I have a second?
Sure, second.
Got a second? Any discussion? Is there any objection to adoption of the second Kendrick Amendment, adding those justice in those locations? Any objection? Hearing none, it's so ordered. Chair recognizes Representative McLaurin.
Thanks, Mr. Chair. This amendment will be an attempt to resolve every comment made about subsection G by all members, and we'll see if I can pull it off. The amendment would be to strike "is intended to" in line 36 and replace that language with or "shall be construed to." So I guess you could just strike "is intended." My pen was a little sloppy. So "is intended" and then replace that with "shall be construed." And then further, after the words "remote proceedings" on line 37, I would add "to the extent they are consistent with this code section."
Okay.
And then and I'll give everybody a second. The final piece of this amendment would be to strike the entire last sentence of subsection G as currently written from lines 37 to 39. So the sentence starting with "the proceedings set forth" and ending in "codify existing practices."
Okay.
So
So we've got discussion about subsection G. Chair recognizes Chairman Burchett for a question.
I was actually going to offer an amendment, so I don't have any discussion to this point, except that I believe that clears up the issue that we had on whether or not this was the appropriate place to insert an intent-based type of narrative. So I don't have any discussion as to this amendment. My apologies.
So, okay. So Representative McLaurin, read the way that yours would read from front to back. Yep, sorry.
Thanks, Mr. Chair. It would read, G, nothing in this code section shall be construed to modify the practices of the courts of this state relating to remote proceedings to the extent they are consistent with this code section.
Isn't that circular reasoning? I mean, that you're saying this code section's not construed to modify anything as long as it's consistent with this code section?
Well, you know, yes and no. I think part of what's being contemplated is that there's a question as to whether the intent of this code section is to modify existing practices or not. And I think you get the basis for this that takes it out of circular reasoning with modify the practices of this courts, because that has a reference point, and that's whatever the practices currently are, which kind of gets to what existing practices was trying to do in the last part of the sentence. So, I mean, I get what you're saying about how it appears circular, but
I mean, if nothing in this act is intended to modify the practice of courts of the state relating to remote proceedings as they existed on January 1, 2021, I mean, that's a date and time. I don't know that you want that, because then you're, in essence, you're really locking in where we are today, and it's memorializing that without putting it in statute, which is, I don't think, the gentleman's intention.
right. I mean, I think that if I'm not wrong, the intention is to, again, clear the way for Rule 9.2 to operate under state law. So, you know, if there's a different way you want to phrase they're, you know, to the extent they're consistent with the code section, I think I mean, you could even take the extent language out. You could just start with say nothing shall be construed to modify practices, and I think that would probably get you there.
And I'm reminded of lines 26 and 27. Nothing in this code section shall limit or prevent Uniform Superior Court Rule 9.2 from being amended or modified as authorized by law. I mean, we're invoking that. I just, and I also am wary of making law on the fly. I mean, I don't want to overstay my welcome as chair. I guess can we, if we were to strike G now could we get language we could all live with to be offered in full committee if there's a policy piece that it's not accomplishing? Can we solve it here? Can we? I think we need to be clear about what we're doing. I'm not clear about what it's doing.
Well, one of the reasons that I added or changed intended to construed in the amendment is because while it is maybe a little strange to put a legislative intent finding in a subsection, it is not at all strange in my experience to put a description of how language is to be construed in the actual code section. So I think if you make it about construction and you say nothing shall be construed to modify the practice of this court or the courts of this state,
Mr. Chairman.
that could be helpful.
Relating remote proceedings as provided in Uniform Court Rule 9.2. I mean,
Okay, well, I'm offering, we have a lot of good minds in here that could work on this for just a minute or two and
Sure.
come up with some really good language. If you want to suspend for a moment and we sit down and have a powwow.
we certainly can. I guess, so your policy objective is to say, nothing shall modify the fact that we're going to follow Uniform Court Rule 9.2. That's what we're saying.
Right.
So yeah, we can absolutely suspend momentarily. Stand at ease. I would just, to the gentleman's remark, it seems nothing in this code section shall be construed to modify the practice of the courts of the state relating to remote proceedings as provided in Uniform Superior Court Rule 9.2. I mean, that may be a place to start, but I'd like if that's so we'll suspend for a moment.
Yeah.
Talk to some folks here in the room, and we'll stand at ease just for a second. What I have ascertained from our standing at ease was that lines 36 and 37, that first sentence, there'd be a benefit to striking the first sentence and moving the second sentence, beginning with proceedings and ending on line 39 with existing practices, could be moved up to a section 1.
Mr. Chairman?
But, yeah,
Do we have an amendment on the table?
there's not. We're still
Okay.
discussing.
Okay, thank you.
So I'm just, what I'm doing is I'm discussing this discussion. So if anyone's observing, they can follow where we are. I'm going to tee up a concept, and I'm going to ask if anyone would deign to move that so we can get it before the committee appropriate time. But since, again, we've got a due pass motion on the underlying bill, the underlying substitute, and we're contemplating an amendment wherein we would, on line 36 and 37, strike the first sentence, nothing in the code section, ending in remote proceedings, and then remove in its entirety, remove the next sentence, the proceedings set forth in this code section, authorized under existing rule of laws of the inclusion, and the inclusion of the procedure set forth in this code section is merely intended to codify existing practices. That would move up to a section 1, which would be legislative findings. And we would renumber accordingly down below. Yes, sir.
Code section to act
Yep.
in both instances.
Yes, indeed. I hadn't gotten there yet, but thank you, sir. Act. So it's code section on line 37 and code section on line 39 would go act, because it refers to the entire act. We would renumber accordingly the sections below. And then there is discussion to eliminate everything after July 1, 2021, meaning it has applicability to offenses committed prior to July 1st and afterwards, so it wouldn't be limited its applicability. And also, for purposes of clarity, on line 5, strike applicability. And applicability. Striking the words "and applicability," because there wouldn't be an applicability component to this. So strike "and applicability" on line 5, strike first sentence on line 36 and 37, and move lines 37, 38, second sentence up to section 1, legislative findings, and change code section to act in 2 places. That would be, and then lastly, eliminate everything after July 1, 2021. That would be period instead of a comma. Are there questions about the proposition? Would somebody state that in the form of a motion? Would someone say so moved? Is there anyone who would like to move that? No. That's what I'm looking for. Thank you. So moved. It's moved and a second. So it's I described it and you placed it in the form of a motion. Thank you. So we've got a motion. Any further discussion on this concept? Hearing none, is there objection to the adoption of the amendment? Hearing none, it's adopted. Any further amendments? Any further amendments? Any further discussion on the committee substitute as amended? Chair recognizes Representative McLaurin for a question.
Thank you, Mr. Chair. I just want to do the quick political thing of noting I think this body did a really good job of rejecting a version of this last year that did not adequately address everybody's concerns. And it's so rare that this body rejects a proposal brought to the floor that I think it indicates the strong support, bipartisan support for this version, which defers to the courts and lets them make rational judgments about how to manage proceedings. So I'm really appreciative of the work everybody's done.
With all due respect to the gentleman, the reference to the rarity of that is perhaps a indication of your, fewer years down here than perhaps others. I think this work happens, and but I would agree with your noting that, and appreciate the work together from all members of the committee. Any further discussion? Hearing none, all those in favor of sending HB 371 LC 280230S as amended by the subcommittee forward with a due-pass recommendation signify by raising either hand. Or both hands. All opposed? Thank you. Appreciate your time.
Thank you, Mr. Chairman.
Thanks for your
Thank you,
work.
committee members. I appreciate it.
And we stand adjourned.